and humanitarian organizations are prevented from rendering humanitarian assistance in solidarity and in fulfillment of their erga omnes obligations. Nor can we accept that journalists, aid workers, and first responders are being assassinated and then hastily buried in mass graves. The United Nations is rightly seized with this matter and calls for the Court's urgent advice on the questions put to it by the General Assembly. Mr. President, members of the Court, this brings to an end the first part of South Africa's oral submission. I kindly request that the Court calls upon Ms. Nokukanya Jele, the Special Advisor to the President of the Republic of South Africa on Legal and International Affairs, to address it on Israel's obligations as an occupying power. I thank you for your attention.
I thank Mr. Dangor. Je donne maintenant la parole à Madame Nokukanya Jele.
I now give the floor to Ms. Okanya Njele. Please, you have the floor.
Monsieur le Président.
Mr. President, members of the Court, it is an honor and a privilege to speak here to you this morning on behalf of South Africa. In an international legal order that prohibits the acquisition of territory by force, the international law rules governing military occupation must by necessity be interpreted in favor of the rights of the occupied population.
Est reste sous l'occupation militaire d'Israël et le droit de l'occupation s'y applique en vertu de la lex specialis. Partant de ce postulat, le droit de l'occupation impose des limites à l'exercice.
I'm sorry. With interpretation.
Can you hear the English translation?
Should I begin again?
Yes.
I shall do so, Mr. President. Monsieur le Président, Mesdames.
Mr. President, ladies and gentlemen, members of the Court, it's an honor for me to present myself here this morning on behalf of South Africa. In an international legal order that prohibits the acquisition of territory by force, the international law rules governing military occupation must, by necessity, be interpreted in favor of the rights of the occupied population. The Gaza Strip and the West Bank, including East Jerusalem, remain under Israel's belligerent occupation, and the law of occupation applies as a matter of lex specialis. Proceeding from this premise, the law of occupation imposes limitations on the de facto exercise of the occupant's power. It invests in the occupying power, as this court observed, a set of regulatory powers on an exceptional basis and on specific enumerated grounds. Israel is under an obligation to respect the lives, rights, and property of the population of the occupied territory, while protected persons cannot be deprived in any manner whatsoever of the benefits of the Convention by any change introduced as a result of occupation. In 2024, the Court declared that it is, I quote, not convinced that the extension of Israel's law to the West Bank and East Jerusalem is justified under any of the grounds laid down in the second paragraph of Article 64 of the Fourth Geneva Convention. South Africa submits that the UNRWA banning laws are also to be declared inconsistent with this provision. Firstly, through these laws and their direct territorial application to occupied Jerusalem, Israel unlawfully purports to assert sovereignty over East Jerusalem. As the law of occupation does not transfer title to assume sovereignty to the occupying power, through this additional measure, Israel extends, as this court opined, I quote, its gradual annexation to Israeli territory and the application of its domestic laws therein, thus impeding the exercise of the right to self-determination of the Palestinian people. Secondly, the occupying power is not entitled to exercise its limited powers in a manner inconsistent with its other obligations under the Convention, cited in great detail by Palestine yesterday. Israel may not impose any measures specifically prohibited by international humanitarian law, such as mass forced displacements, the destruction of property, transferring in of colonial settlers, targeting schools, and even targeting the school curriculum to erase the history of the Palestinian people. Israel is not entitled to subject the population to collective punishment while indiscriminately bombing civilians and civilian property on a large scale, acts which are manifest violations of its obligations as an occupying power. Thirdly, as part of its duty to ensure public order, to protect the lives and security and safety of civilians, Israel must act in a manner consistent with its obligations under international humanitarian and human rights law, which prioritize the well-being of the Palestinian population. This includes not preventing, impeding, or restricting collective relief schemes, which Israel shall agree to and shall facilitate by all the means at its disposal, without exception. This includes respecting the privileges and immunities of the United Nations, which operates such relief schemes, as well as allowing entry into and movement within the occupied Palestinian territory. Any dismantling of Palestine's quasi-state institutions, including those administered by UNRWA since 1949, would risk resulting in a complete breakdown of public order and civic life, and would be an act, and is an act clearly intended to destroy the viability of the Palestinian state. Such a decision would target constituent parts of the Palestinian housing, education, and healthcare system. The dissolution of such institutions is prohibited under Article 47 of the Fourth Geneva Convention, as part of its obligation to bring to an end its unlawful presence in the occupied Palestinian territory as rapidly as possible. Israel must halt its unlawful administration over movement and entry into the occupied Palestinian territory under jus ad bellum. Mr. President, members of the court, several states have in their written submissions outlined Israel's affirmative obligations under the Fourth Geneva Convention. Israel retains primary responsibility for the implementation of its obligations under the provisions of that convention. No exception or qualification is provided for in these provisions. Article 69 of Additional Protocol 1 expands the nature of the goods that are to be supplied, taking into account local conditions. These unqualified obligations include an obligation on Israel not to obstruct entry into and freedom of movement within the occupied Palestinian territory of humanitarian relief personnel. The occupying power also cannot refuse to allow and facilitate the rapid transit of humanitarian aid through its territory as relates to relief equipment and personnel essential to the survival of the civilians. Security Council Resolution 2720 of 2023 demanded the full implementation of Resolution 2712 of 2023, which called for the provision, I quote, of inter alia water, electricity, fuel, food, and medical supplies, as well as emergency repairs to essential infrastructure. End of quote. It also demanded that all parties comply with their obligations under international law, including international humanitarian law, and called for access, unfettered access for United Nations humanitarian agencies and their implementing partners. The court's orders of 26 January, 28 March, and 24 May 2024 constitute additional legal obligations for Israel to allow and facilitate the unimpeded passage of humanitarian aid into the Gaza Strip, I quote, in full cooperation with the United Nations, end of quote. However, Israel has blatantly ignored these binding obligations. Instead, 1.5 months after its legislation banning UNRWA went into effect, it has intensified its denial of aid by imposing a nearly 8-week-long blockade on Gaza. South Africa has published 2 public dossiers which set out in detail, amongst others, Israel's denial of aid policy. UNRWA is not engaging in, and I will quote their written submissions, is not engaging in a one-sided politicized advocacy, but rather acting in accordance with its obligations recognized by the UN General Assembly as a, I quote, global advocate for the protection and care of Palestine refugees, end of quote, along with the UN's customary obligations not to recognize as lawful the unlawful presence of the State of Israel in the occupied Palestinian territory. Israel's allegations are calculated and deliberate in a context in which Israel has imposed a blanket ban on all humanitarian organizations and the delivery of humanitarian relief to Gaza by third states. This includes new restrictive procedures seeking to further shutter any humanitarian organizations operating in the occupied Palestinian territory. Mr. President, members of the Court, South Africa submits that sovereignty is always retained by the people of an occupied territory. The people of Palestine, through their chosen representatives, have consented to receiving humanitarian aid and to the presence and activities of the UN and third states in the occupied Palestinian territory. The law of occupation, and in particular, Articles 59 to 61 of the Fourth Geneva Convention, do not require an occupying power's consent in cases where the civilian population is inadequately supplied. It is therefore the law of occupation, and particularly Articles 55 to 61 of the Fourth Geneva Convention, which are applicable to the occupied Palestinian territory, requiring Israel not only to, I quote, enable, but also to, I also quote, ensure the provision of aid and basic services. Further, Article 11 of the Fourth Geneva Convention clearly envisages a role for humanitarian organizations as substitutes for protecting powers for the protected civilian population. The United Nations have continued to play a protecting role for the benefit of the Palestinian people, who were guaranteed full self-determination as a Class A mandate and were subsequently dispossessed of their territory and forcibly displaced during the Nakba in 1948, which made necessary the creation of UNRWA to guarantee the rights of Palestinian refugees, including the rights of over 70% of Palestinians in Gaza, who have been systematically denied their right to return to their homes. As part of Israel's unlawful occupation, Israel is completely ignoring its need to fulfill its obligation as an occupying power, but rather it seeks to wrongfully usurp rights. Israel's conduct and omissions clearly violate the law of occupation as a whole, and its grave breaches of international humanitarian law cannot be allowed to persist. Mr. President, members of the Court, this brings to an end the second part of South Africa's submission. And so, Mr. President, may I request that you invite Mr. Jamian Hendricks, State Law Advisor for International Law, to address the Court on South Africa's conclusions.
Madame Gillet, I now invite Mr. Jamian Hendricks to address the Court. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Republic of South Africa. International law prohibits Israel from the use of starvation as a method of warfare, including under siege or blockade. Israel may not collectively punish the protected Palestinian population, which it holds under unlawful occupation. The UN Special Rapporteur on the Right to Food, in his report of 17 July 2024, stated, "Starvation reflects a state's fundamental abandonment of its human rights obligations," and further, that the State of Israel has deployed the full range of techniques of hunger and starvation, perfecting the degree of control, suffering, and death that it can cause through food systems, leading to this moment of genocide. Despite the horrific attempts by Israeli officials to characterize them otherwise, Palestinians are human beings. They are flesh and blood. Palestinian people are entitled to the same fundamental protections as we in this great hall of justice. And this includes the right not to be arbitrarily deprived of life, the supreme right from which no derogation is permitted, even in situations of armed conflict. Israel's humanitarian blockade, including its ban of UNRWA, renders the Palestinian population significantly less resilient to Israel's acquisition of territory by force and of its genocide. In so doing, Israel is breaching the right to self-determination of the Palestinian people, a peremptory norm of international law enshrined in the UN Charter and Common Article 1 of the International Covenants on Human Rights. Furthermore, Israel is impeding the United Nations and third states from exercising their erga omnes obligations and international solidarity with respect to the exercise of the fundamental human rights of the Palestinian people, which this court held to include the right to self-determination. In relation to Israel's obligations towards the United Nations, the 1946 General Convention provides for no exceptions to the inviolability of the United Nations, which applies equally in times of peace and in armed conflict. States are under a legal obligation to protect the inviolability of all UN premises and property, wherever located and by whomever held. Israel must therefore cooperate in good faith with the United Nations and render it every assistance. And despite its abrogation of its bilateral and operational agreement with UNRWA, Israel's obligations under the UN Charter and the General Convention prevail. Mr. President, members of the court, turning now to the legal consequences which flow from the question before the court. South Africa submits that Israel's unlawful occupation and its aforementioned violations of peremptory norms of international law constitute internationally wrongful acts attributable to the State of Israel. This necessarily invokes the law of state responsibility. Israel must therefore immediately cease its internationally wrongful acts and make reparation in full, including through restitution, compensation, and satisfaction. Israel must comply with its obligations as an occupying power to ensure food and medical supplies and facilitate the unhindered provision of humanitarian goods, essential services, and development assistance by the UN, third states, and other international organizations. It must fully cease hostilities to ensure their ability to deliver assistance. Israel must comply with this court's binding provisional measures in South Africa versus Israel and take effective measures to ensure, without delay and in full cooperation with the United Nations, the unhindered provision at scale and by all concerned of urgently needed basic services and humanitarian assistance to Palestinians in Gaza. Finally, Israel must immediately reverse its decision to expel UNRWA and other UN bodies from carrying out their mandated activities. Turning to the obligations on the United Nations, the United Nations and its bodies are under a duty not to recognize Israel's internationally wrongful acts, such as its unlawful eviction of UNRWA and its unlawful powers reserved for the legitimate sovereign in Palestine. And despite Israeli restrictions, the UN and its agencies, including UNRWA, must continue to render humanitarian assistance to the Palestinian people. It must demand and negotiate for the removal of barriers imposed by Israel. Turning to the obligations on third states. Third states have an obligation not to recognize as lawful Israel's internationally wrongful acts, including its banning of UNRWA, not to maintain these acts, and to collaborate to bring such acts to an end. It is imperative that third states refrain from providing arms which enable Israel's continued breaches of international law in the occupied Palestinian territory. Mr. President, members of the Court, in conclusion, South Africa shares the UN Secretary General's view that the world has failed the Palestinian people. The only certainty they have is that tomorrow will be worse. Therefore, we must save whatever is left of our humanity by ending Israel's unlawful settler colonial occupation and its intentional starving of the Palestinian population, who are being systematically brutalized and deprived of the most elementary considerations of humanity. Palestinians look to the world and to this court for an end to their enduring loss, their pain, and their suffering. Mr. President, members of the court, this brings to an end South Africa's oral submission. I wish to thank the court for your attention.
I thank the representatives of South Africa for their presentation. J'invite à présent la délégation de la...
I now invite the delegation of Algeria to take the floor, and I would like to call to Madame Maya Salih Fadel to make her presentation.
All right, and so that rounds off South Africa's submission in that ongoing hearing taking place at The Hague at the International Court of Justice. Essentially, this is about evaluating Israel's obligation when it comes to providing humanitarian aid in its occupied territories, including in the main in Gaza. It's a story that dates all the way back to the time when Israel itself essentially banned the UN Palestinian Human Rights Agency from occupying or from operating in occupied territories. And the impact of this is that millions of Palestinians have had their supply of humanitarian aid completely cut in some instances because of that decision. In response, about 45 countries have now banded together, including South Africa, to approach this court to give out an opinion about where, in fact, Israel's obligations lie insofar as humanitarian aid is concerned as a member of the United Nations. And that's why there's no surprise there's the mentioning of the 4th Geneva Convention multiple times. It essentially governs just how you treat civilians in the context of war. I mean, it's a very watered down definition, but that's in the main what it's about. And South Africa, in their own submission, have made reference to that convention multiple times. You've heard there a call for third states to refrain from providing arms as part of this conflict, and a reiterating of sentiments from the United Nations General Secretary, who's mentioned that the world has failed the Palestinian people. We'll continue watching the story for you. In fact, stick around. In the next hour, we'll speak to our correspondent in Brussels, who's been watching today's proceedings and will help us distill them as we continue listening in to the weeks-long submissions from these countries at The Hague.